Constitution insofar as they take away the power of judicial review vested in the Supreme Court, Article 32 of the Indian Constitution, and in the High Courts, Articles 226 and 227 of the Constitution, while the tribunals constituted under Articles 323A and 323B of the Indian Constitution can be vested with the power of judicial review over administrative action, but the power of same on legislative action cannot be conferred upon them. This proposition that only constitutional courts, High Courts and Supreme Court, have been vested with the power of judicial review of legislative action flows from the judgment given in the Kesavananda Bharati v. State of Kerala case, 1973. The decision in the case of Sampath Kumar v. Union of India, 2016, was given on the hope that the tribunals established would be effective and efficient substitutes, but it was neither legally nor factually correct. It was held in this case that Section 28 of the Administrative Tribunal Act, 1985, which excludes the jurisdiction of the High Courts, Articles 226 and 227, is not unconstitutional. It was also held that this section does not totally bar the provision of judicial review. The tribunals established under the Act are the substitute of the Constitutional Court. High Courts and will deal with all service matters, even involving Articles 14, 15, and 16. The petitioner argued that there is a huge difference between the High Court and these tribunals. They argued that the High Courts have been in existence since the 19th century, and people have gained confidence in it. The tribunal is a new creation of the executive that would not be able to create similar confidence in the people and a positive environment overnight. They argued that Section 5(6) of the said Act allows only a single-member bench of a tribunal to test the constitutional validity of a statutory provision which is also unconstitutional. The argument from the side of the respondent are as follows. The jurisdiction of the Supreme Court, Article 32 of the Constitution, is sacrosanct and is indisputably a part of the basic structure of the Indian Constitution. This position had been clearly enunciated by the Parliament well before the 42nd Amendment and Administrative Tribunal Act was conceived. Therefore, the position of the Supreme Court jurisdiction is not affected in any way. However, the jurisdiction of the High Court under Articles 226 and 227 was sought to be removed by creating an alternative institution. Articles 323A and 323B of the Indian Constitution do not exclude the supervisory jurisdiction of the High Courts on all the tribunals established within its territorial jurisdiction. Therefore, the High Court still has the power as a supervisory jurisdiction and corrective mechanism body. It was argued that the tribunal should allow exercising the jurisdiction under Article 226 and 227 of the Indian Constitution. It was said that the theory enunciated by the petitioner from the case of Sampath Kumar Frere, UOI 2016, is not valid. It is based on sound considerations and doesn't require any reconsideration. Judgment. The judgment was delivered by the Constitution Bench of 7 judges. The bench observed that the judicial review is the most essential and basic structure of the Indian Constitution. Similarly, the jurisdiction conferred under the Article 32 on the Supreme Court and under the Article 226 and 227 on the High Court is also a part of basic structure which cannot be amended and altered as the decision given by the bench in the Kesavananda Bharati case. It is also said that for securing the independence of the judiciary, the superior courts have been given the power of judicial review. Though the Indian Parliament has the power and right to amend the Constitution, it cannot amend the basic structure of the Constitution. It was held that Section 28 of the Administrative Tribunal Act, 1985, excludes the power of judicial review of all the High Courts, and the exclusion of jurisdiction clauses in all other acts and legislations enacted under the aegis of Article 323A and 323B would be ultra vires of the Constitution. The jurisdiction conferred on the Supreme Court, as well as on the High Courts, is part of the inviolable basic structure of the Constitution. Thus, Clause 2D and Clause 3D of Articles 323A and 323B of the Indian Constitution, to the extent that they exclude the jurisdiction of the High Courts, are unconstitutional. It was also held that there will be no constitution prohibition against the tribunals. In performing a supplemental role, they will not be considered as the substitutes of the High Courts or the Supreme Courts. The decisions given by the tribunals will be subject to scrutiny by the division bench of the High Court, within whose jurisdiction the concerned tribunal falls. Lastly, the court upheld that Section 5-6 and Sections 5-2 of the Administrative Tribunals Act 1985 must operate together and be harmoniously construed, and